Hello, blog readers. I'm here with top employment lawyer Jerry Mettman to discuss the newest edition of the Workplace Class Action Report for 2017. One of the 6 key workplace class action trends of 2016 has been the Supreme Court and its rulings. Jerry, has the Supreme Court been pro-worker or pro-employer?
Great question. It illustrates the point that one man or one woman can make quite a difference. Right now, the Supreme Court, with the death of Justice Scalia, only has 8 members, 4 and 4, and there's a very fragile alliance between liberals and conservatives. And although the Roberts Court often is deemed to be a pro-business Supreme Court, its class action rulings and employment-related rulings are anything but. They're very nuanced, and I think another way to look at the court are its decisions such that they open the courthouse doors and make the filing and prosecution of class action litigation easier or harder, or whether or not the cases favor employers or favor workers. I think at this point you'd have to conclude it's a mixed bag, and the rulings are an array of touch points across the screen.
How do you think the rulings of the Supreme Court affect other litigation?
Well, the Supreme Court, even in cases that aren't clear, either open the courthouse doors or close them in terms of making class actions harder to bring, harder to certify, or harder to keep together when employers bring motions for decertification. Dukes v. Walmart from 2011 is viewed by many as raising the bar, making class actions harder to bring, harder to win, easier to defend. Perhaps the 2013 decision in the Comcast case is the same, but in 2016, I think the key decision of the term was the Tyson's Food case, in somewhat peeling back the restrictions that employers have enjoyed based on the Walmart and Comcast cases, and in essence making certification of a case easier and pursuit of damages easier. So I would look for 2017 to be a year where plaintiffs' lawyers are challenging lower courts to expand the teachings in the Tyson's Food case to expand exposure for employers on the class action front.
So what were some of the top employment lawsuits brought before the Supreme Court in 2016?
Well, I think the Tyson's Food case would be the #1 case. Spokio would be another one involving the Fair Credit Reporting Act, and also another decision that I think you'd have to characterize as a door opener in so far as it did not define explicit limits that would kick various cases out of court. And then in 2016, a cert petition was filed in a series of cases involving the legality of class action waivers in arbitration agreements. On January 13, the Supreme Court accepted those cases for review. They're known as the Murphy Oil series of cases, and I look for that to be the big case in 2017 that both the plaintiffs' bar and employers will be watching in terms of whether or not employers can use arbitration agreements to manage their class action exposures.
Fascinating. Our blog readers will have to stay tuned to our blog as the litigation on these cases continues to unfold. Readers, don't forget to request the newest edition of the Workplace Class Action Report for 2017. Thanks for your time, Jerry.
Thank you.